This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we explain why if there is no damage, you have no case, and why a broker is sincerely more different than an agent or an insurer. They are not the same thing. Knockerball MidMo LLC appealed from the judgment of a trial court granting McGowan Company, Inc.'s motion for summary judgment on Knockerball's claims for negligence and breach of fiduciary duties. In Knockerball v. McGowan, the Court of Appeals of Missouri, on May 9, 2023, dealt with the issues raised and resolved the dispute. McGowan, in its capacity as Knockerball's insurance broker, and Sportsinsurance, in its capacity as managing general agent for a liability insurer, assisted in procuring general liability insurance coverage for Knockerball in the amount of $1 million, and the liability insurance policy covered the time period when a person by the name of Hart was severely injured on Knockerball's premises. Hart sued Knockerball for personal injuries. Knockerball was served and promptly notified McGowan of the underlying suit and provided a copy of the petition to McGowan. McGowan's representative assured Knockerball's managing member that McGowan would handle it. However, through a variety of missteps by McGowan, Sportsinsurance, and the liability insurer, no responsive pleading was timely filed on behalf of Knockerball, and the order of interlocutory default against Knockerball was entered in the underlying suit. Knockerball then entered into an agreement with Hart that contained the following provisions. Hart and Knockerball, and for the consideration of $10 provided to Hart by Knockerball, agreed to settle and assign rights against the broker and the insurer. Thereafter, a bench trial on damages was held, at which Knockerball did not cross-examine witnesses or object to the evidence Hart's attorney offered, and on July 13, 2017, the court in the underlying suit entered a final judgment for Hart against Knockerball in the amount of $44,631,268.99. It was undisputed that Knockerball did not incur any attorney's fees for the defense of the underlying suit, and Hart is prohibited from attempting to collect any portion of the judgment in the underlying suit against Knockerball or Knockerball's managing member. The trial court found that it was undisputed that not only was Knockerball protected from liability on Hart's claims, but it also stood to collect in excess of $1 million as a result of the resolution of actual coverage claims. Therefore, it was difficult to see how Knockerball had been damaged and that such damage was proximately caused by McGowan's conduct. The case is not a bad faith refusal to settle case against the liability insurer or an insurer's general agent. Simply put, there is a difference between an insurance broker such as McGowan and a general agent for the insurer such as Sportsinsurance. While an agent represents the insurer, an insurance broker, unless otherwise authorized and provided, represents the insured, and unless otherwise shown by the evidence, is to be regarded as the agent of the insured. Knockerball's claims against McGowan are for negligence. The circuit court granted summary judgment in favor of the insurance broker, and the insured appealed, asserting that the trial court erred in concluding that the insured sustained no damages resulting from the insurance broker's failure to procure adequate insurance coverage. The judgment in the underlying suit was entered after Hart agreed that he would not levy execution by garnishment or otherwise provided by law or otherwise collect or attempt to collect on any property, asset, or right of Knockerball for any portion of the judgment entered against it in the underlying suit. Instead of Knockerball suffering damages from a $44 million default judgment, it actually received $1.25 million from the Liability Insurer's settlement of Hart's claims against the Liability Insurer. Knockerball actually profited from its own business premises negligence due to the corresponding settlement of Hart's coverage and bad faith claims. The Court of Appeals concluded that Knockerball had not been damaged as a result of the judgment entered against it in the underlying suit. Knockerball has not established that it sustained pecuniary damage as a result of McGowan's alleged negligence and breach of fiduciary duties to Knockerball as Knockerball's insurance broker. Without damages, the trial court's summary judgment ruling was not erroneous, and Knockerball's appeal is without merit. In my opinion, although the broker was negligent in not immediately forwarding the notice of the suit to the insurer, the resulting actions of the insured and the plaintiff to allow action against the insurer and the brokers resulted in Knockerball incurring no damages, but in fact profiting from the situation. This part of the case was, in my opinion, a waste of judicial time, and the court, quoting the and now dearly departed announcer for the Los Angeles Lakers, Chick Hearn, there was no harm because there was no foul. And you can't have a foul if you have no harm. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. And you can subscribe to the blog easily and receive notice of every blog posting in the future by email. In addition, you will have access to the more than 4,500 blog postings and the more than 650 videos on rumble.com and youtube.com. And you can also subscribe to the videos for free, no cost to you, and no advertisements, although I'd like to have some, there are none. If you like the videos, please click on the like button, and if you found them to be useful, please tell your friends and colleagues so that they can also subscribe to the blog and the videos. Thank you for your attention.